This video is called Will My Criminal Case Stay in the Local Court or Go to a Higher Court such as the District Court or the Supreme Court? Now, I'm often asked by clients, will I have to come before a judge and a jury in the District Court or the Supreme Court, or can I stay in the local court before just a magistrate in the local court? Where will my case go? Now, it's better generally that a person's matter stays in the local court rather than goes up to a higher court. The reason is, in the local court, penalties are generally less. So for a single charge, the maximum penalty in the local court is 2 years. In a higher court, of course, it can be whatever the maximum penalty is applicable to the offence. For example, it could be 20 years, 25 years, it could be life. So generally for that reason, it's better to stay in the local court. Now, a second reason why it's better to stay in the local court is because you have a right to appeal to the district court from the local court. So if you don't like your penalty in the local court, or if you're found guilty in the local court, you have a right to appeal to the district court, and the appeal will come up reasonably quickly. And very importantly, in practical terms, you cannot get a higher sentence in the district court than you got in the local court. So before a district court judge can give you a higher penalty in the district court, if you appeal to the district court, the judge has to give you a warning, or has to give your lawyer a warning. So in practical terms, if you appeal from the local court, so you don't like your decision in the local court, you don't like the penalty, and you want to appeal it, then you won't get any higher sentence in the district court. So for that reason, it's good to stay in the local court. And it all depends on the type of case that you have, so the type of charge that you have, and also the question of whether the DPP, so the Director of Public Prosecutions, or you, if you would like to, want to elect to take your matter up to the District or Supreme Court. So that's the thing that really affects whether or not a matter goes up to the District Court or not. The type of charge, and also whether an election is made to take it up to a higher court. Now, there are 4 broad categories of criminal offences. So going from the least serious to the most serious, the first are called summary offences, the second are called Table 2 offences, the third are called Table 1 offences, and fourthly and most seriously, there are strictly indictable offences. The first and least serious category of offences are called summary offences. Now, summary offences carry a maximum penalty of 2 years or less, and they include offences such as crimes under the Summary Offences Act, or less serious offences under the Crimes Act, for example, drug possession, and they must be finalised in the local court. So if you're charged with one offence, so for example drug possession, and that carries a maximum penalty of 2 years imprisonment, and you're not charged with any more serious offence with it, then that case will always stay in the local court. It won't go up to the district court. The second category of offences are called Table 2 offences. So they're the next level up from summary offences. Now, Table 2 offences will stay in the local court, so they will be dealt with summarily in the local court unless the prosecution elects, that is, chooses to take the matter up to the district court. In making that decision, the prosecution will normally consider how serious the actual incident is, so the actual facts of the offence are. Also, a person's criminal history. So if they have a criminal history, serious history, it's more likely that they will elect to take it up to the district court, and things of that sort. So Table 2 offences are a little bit more serious, like I said, and they include, for example, assault occasioning actual bodily harm, stalking and intimidation, larceny, so stealing of an amount that's less than $5,000, and offences of that type. They're Table 2 offences. The next level up in terms of severity are called Table 1 offences. Now, Table 1 offences are dealt with in the local court unless the prosecution or the defence chooses to have the matter dealt with in a higher court, such as the district court or the Supreme Court. What that means is the defendant, if he or she pleases, can choose to have that matter dealt with in the district or Supreme Court, so before a judge and a jury, if the person so wishes. These are quite serious offences. They include offences such as reckless wounding, aggravated indecent assaults, larceny, so stealing where there's more than $5,000 that's alleged to be stolen, and offences of that sort. So they're Table 1 offences. The fourth and most serious category of criminal offences in New South Wales are called strictly indictable offences. Now, these are very serious types of crimes, and they must be finalised in the higher courts, that is, in the District Court or the Supreme Court. They cannot be finalised in the local court. So if you are charged with a strictly indictable offence, and you'll be able to tell what sort of offence you're charged with by either talking to a criminal lawyer or even looking at your police papers. If you look at your police papers, next to the charge it may well say T1, Table 1, T2, Table 2, or SI, strictly indictable, and you can determine in one of those ways whether you are charged with a strictly indictable offence or what type of offence you are charged with. Now, strictly indictable offences, they include serious offences such as wounding or grievous bodily harm with intent. They include supplying more than an indictable quantity of a prohibited drug. They include sexual assault type cases. They include murder cases. So very, very serious cases. Now, I'm of the view that it's normally beneficial for a person's case to remain in the local court for a range of reasons, not the least of which is that the local court has lower penalties, generally speaking, than the higher courts, and also for price. It's normally cheaper if the case remains in the local court than if it goes to the District or Supreme Court before a judge and a jury, are those reasons. Now, if I were charged with a more serious offence, such as a strictly indictable offence, I would ask my lawyer what they can do to try and ensure that my case stays in the local court. That is, how they will fight to have the charge dropped, the strictly indictable charge dropped, on the basis that I plead to a less serious charge. For example, if a person is charged with a serious supply, the lawyer may well be able to fight to have the supply charge withdrawn on the basis that their client pleads guilty to possession. Another example is if a person is charged with a very serious assault, such as intent to cause grievous bodily harm, the lawyer may well be able to fight to have that charge withdrawn and replaced with a lower charge, such as assault occasioning actual bodily harm. The best thing to do, in my view, is to see an experienced criminal lawyer, ask them which court my charge is likely to finish up at, and ask them what they will do to ensure or give me the best chance that my charge will stay in the local court.